Welcome to Leaving a Legacy, Navigating Estate Planning with Rose Harper Law.
Hello and welcome to Leaving a Legacy, Navigating Estate Planning with Rose Harper Law. I'm your host, Sophia Morales, and owner Rose Harper is joining me today to discuss debunking probate, separating myth from reality. So welcome, Rose. So happy to have you here for this conversation today.
Yeah, thank you. I'm excited.
So let's just address the elephant in the room. I think there are a lot of misconceptions out there around probate. What are some of the common misunderstandings people have when it comes to that process?
Well, the first being that I think that a lot of people don't even realize that their estate might have to go through a court process. So, if someone passes away and they don't have a will, their estate has to go through the court system. And then if they have a will, their estate still has to go through the court system.
Oh, that doesn't seem fair. I went to the trouble to create a will. Why do I end up in probate anyway?
Yeah, so, the courts essentially are required to oversee the administration of your estate unless you have a trust. So, the probate process goes through the surrogates court in New York, and the executor of the will, if you have a will, or your next of kin, if you don't have a will, would petition the court. And I think misconceptions people have about the probate process is it's easy, it's quick. I don't have many assets, so might as well just go through the court system. I don't need a will.
Not going to be a big deal.
Yeah, I think people think like, oh, it's not a huge deal. But you have to remember that if you've passed away, your family is under stress. They need to grieve. And instead of going through that grieving process and figuring out life, without you, they're now having to engage in this court process, which is very stressful. The executor of your will or the next of kin that petitions the court becomes personally responsible. They're a fiduciary of your estate and they're liable for what they do and don't do throughout the process. It's very stressful, even in small estates. People reach out to have me help them through the probate process because there's a lot to do. It can get really complicated very easily. And, it's not as easy as people think,
Yeah.
especially because you're already grieving.
Yeah, you've got grief brain going on, and then to add all this detail work on top of it, my goodness. So, what does the probate process look like in New York?
So in New York, if someone passes, with a will or even without a will, but there's no trust, they have to either the executor of the will, or if there's no will, the next of kin will petition the court. So you petition for probate in the surrogates court. And as a part of that process, there's things that you need to bring with you, but essentially you petition the court to get appointed to handle the estate, either as the executor or the administrator. And then you have to notify everyone who is a potential beneficiary. There's a probate hearing possibly, and there's kind of a process in place. But essentially, just to keep it basic, is your job is to gather all of the assets of the estate, pay off any debt, and then distribute the remainder with the guidance of the court system. But along the way, there are things that can come up. People can contest things. There's a lot that occurs, but but
Yeah,
that's a very basic part of it.
excellent. What are some of the key documents that you need to be able to get that process started in New York?
Yeah, so the documents that you're going to need is you're going to need the original will, if there was one. You're going to need a certified death certificate. And there's an actual petition, like you'll have to fill out a petition for the probate court. There's something called an executor's affidavit. You'll need a list of all the heirs and beneficiaries. You're going to want to know like overall value of the assets and an inventory of the assets. Some of this you can do after you petition the court, but it's a good idea to get that all going,
Yeah, scraped into a pile.
yeah, start getting a list going. You might need to get renunciation of the right to serve. Like, say, for example, you have a group of siblings that all potentially could be, the person in charge of probating the estate, but maybe you, as siblings, decide like only one of you is going to do it. In that case, you can get the other siblings to basically renunciate their right to serve as executor and appoint you. That makes it a little bit easier for the court system to appoint just one person. There might be a bond required, which is essentially an insurance, just protects the estate so that, prevents someone from running off with all the money. Um, well, sometimes that's required. And,
Sure.
bond, you have to have a certain credit score to qualify. You have to put money down. So there's a process there. Usually in wills, we'll draft it so that there's no bond required. But if someone passed away and did not have a will and the person lives out of state or whatever the case may be, the court might require a bond. So that's something to consider as well. Um,
Wow.
yeah, so there's a
There's
lot.
a lot of pitfalls here.
Right. There's definitely a lot that goes into it, but that's kind of the basics of what you would need to get going with your petition.
So how long does this process typically take? Is it kind of, well, you can expect X amount of time, or does it vary quite a bit?
It really varies. It really depends. The court process could be, 9 months. It could be 15 months. It really varies depending on the size of the estate, whether it's contested or not, meaning if family members are fighting over who should be in charge or what should happen. You could have a situation where one family member wants to keep the house and is trying to buy it. That delays things. So it really varies. And it depends on if you have everything I listed up front, like ready to go. That's why at least getting your will done that has that financial inventory of where all your assets are held and what's in there, that makes it a lot easier. Those estates can go much more quickly, versus someone who passes away with no will. Nobody knows where your bank accounts are. We're waiting for mail to come in to find out where your stuff is, if it even comes in, because a lot of times now you have only email notifications on your accounts. But yeah, so it really, really varies. It just depends on if there's, conflict within the family or where your assets are held and how they're held and things like that.
So what role does an executor or an administrator play in this probate process, and what are their responsibilities?
Well, in that role, you have a fiduciary obligation. So you have a duty to ensure that everything is done according to the law. And that's a really big responsibility. It's not just the surrogate court is not going to take liability. So they're not going to advise you. So,
Mm.
yeah, they can give you like a checklist of suggestions of things you have to do, but they're not advising you on the law. They're not going to take liability for the estate and have you do something wrong. That's why also getting an attorney, even if you have to go through the probate process, is probably a good idea because the attorney can advise you what the law requires of you to do and ensure that you're, complying with that.
So what are some of the potential ramifications if you make even a good faith mistake as you're going through this process unadvised?
I mean, it really depends because there could be so many different things that could occur, right? And it depends on like, is it able to be fixed within the process? Is it something you can bring to the surrogate's judge, attention and just say, it just depends on what the situation is. It really varies. But I mean, I think the whole point is like it's a really big responsibility. You have a fiduciary duty to ensure that things are done correctly and that you're documenting everything that you do. So it's not something to be taken lightly. Like if you're not a person who's going to be able to like keep track of all your receipts, what you're spending money on, money coming in and out, it might not be the best role for you unless you can then hire someone to help you, navigate it.
Yeah, keep track of the P's and the Q's. So, what strategies can individuals use to avoid probate altogether? Because it seems to me from our discussion, this would be a very desirable thing.
Yeah, in order to avoid probate, you can get a trust-based plan put together. And with that trust, it's just essentially a legal agreement stating that the property that is owned in the name of the trust or by the trust won't have to pass through the court system in order to change hands. The successor trustee can have the ability to buy and sell, manage the assets, and things like that without having to go through the court system. But again, it's only the property that is owned by the trust. That trust is only going to cover, the terms of that trust will only cover the properties that are within it. So you create the trust, and the date of birth of the trust is the signing day, the day you sign that agreement. And while you're alive, you're the trustee, you're the creator, the grantor, and you're the beneficiary. Once you pass, those roles change to whoever you listed. And the trust has a lot of different conditions and terms and things that you choose in designing your trust about what you want to happen. But essentially, once that trust is established, then you work on titling your accounts into the trust. It's called funding the trust, but you definitely want to make sure that your assets are moved into the trust so that that's don't have to go through the court system.
Okay. So what I'm hearing from you, it sounds like it'd be a real good idea to review your financial situation periodically once you have the trust to make sure nothing gets left out.
Yes, exactly. So as you open new accounts, hopefully you'll remember, wait a minute, I have a trust. Let me add the trust to this account, either as the owner or the second beneficiary or something like that. So it just depends on what type of account it is, where it's located. There are different ways that you can get it.
Nice. And would a reminder be something that a client of yours would be able to expect to receive once they've got something like this established?
Yeah, so I offer like a flat rate package if you want us to do all the funding of your trust. That's for people who maybe have a lot of different properties. They have 20 different, accounts, and they're both working. They have young kids. They have no time. They'd rather pay me to do it. So I offer a package like that. But for most people, if you have some time, you can contact the banks where you are, get their form, fill it out, and transfer it yourself. So I give instructions on how to do it. You could save some money and do it yourself. But usually I'll say, like, if in 6 months you have not done that, reach back out and you might want to consider paying us to do it for you. Or every 3 to 5 years, I usually reach out to my clients and just say, like, hey, I'm just checking in. Has anything changed in your life? Have you moved? Are there any circumstances where you might need to update something? Just to have that check in and make sure, we want your plan to actually reflect properly, what your assets are at the time.
Exactly, the current circumstances, because it all evolves. I love that. If someone's kind of on the fence of, do I need a trust? Do I not need a trust? What are your words of advice to them?
I would, get a consultation with an estate planning attorney. It's something that I do every day. As a part of like a 45-minute family wealth planning session, I sit down with my clients and talk about their specific family dynamics, their assets, and what their goals are. And then I talk to them about, what would happen in certain situations if they only have a will versus if they have a trust. Versus if they have nothing. And that way you kind of get legal clarity, financial clarity on how you want to move forward. And then people choose, either they want to go for the trust, or they're okay with their family going through the court system and they want to just do the will and get their wishes documented. Because ultimately it's your estate plan and it's what you want to happen. But I think at a minimum, getting your will done is an amazing gift to give your family, and the trust as well. If you're ready to invest in a trust and ensure that those assets pass seamlessly to the next generation, that's great as well.
I like that. So thank you for joining me today, Rose. This has been very informative.
Thank you so much. It's been great.
Thanks to everyone for tuning in to Leaving a Legacy in Navigating Estate Planning with Rose Harper Law. To connect with Rose and her team, head over to roseharperlaw.com and be sure to like, subscribe, and review on YouTube to help us with the algorithm so this information reaches more people. Bye.
Bye.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.